session. We won't have any breaks in between. Nazim is happy to answer your questions. If you could put your hand up, and maybe I can direct you, or if when he's open to taking questions at the end, do put yourself on mute if you're not speaking, just in case there's any disturbances in the background, so he's not disturbed. And I hope you have questions which he can assist you with today. But he's very kindly offered support for 15 minutes, a one-to-one call, or quick support if you require afterwards, if it is something which cannot be shared at the session.
Yes, I am happy to be interrupted when I'm talking, so do excuse me fidgeting about. I'm just trying to find a good position where the light's not going to be hitting your eyes. But yes, do interrupt me if you have a question, or put it in the group chat. And if it's in the group chat, Nayoka, if you could let me know, because I've got it on screen sharing and I can't see that screen today for some reason.
Yeah. So no, yeah. I will do that. Thank you for reminding me on that. If you don't mind putting in your name, your organization, and contact details in the chat for us right now, we'd be able to connect with you, or whoever's at the session can network with you today. So this works as a training come networking event. Help us bring us all together, supporting each other. So Ian, my colleague, is here. As I mentioned, Jenny, who takes care of the Hounslow Borough. Welcome, everybody. Welcome, Lalit.
Sorry, no, I'm from Ealing. Sorry.
Oh, great. So I'll be your, I'll be there for you. Okay. I have 8 participants who've joined us. Do you think we should begin?
I can give it a few more minutes if you like.
Okay, we'll wait for a couple of minutes then.
Yes, you'll have to look at a bad impersonation of Rick Grimes, but yes.
Yeah, people are still joining. I think we'll wait for a couple of
so
chance to join us. At the end of the session, we'd like feedback on today's session. So please do give us that feedback. It's just a minute or two, but it's really, really important for us to understand what we need to bring to you, and whether the session that's presented before you is effective. So don't forget to leave us that feedback.
Yeah, and if you have any suggestions or any advice that you all want, that'd be quite helpful. I know there's changes with the IR35, so if you want to know about worker status, or how to conduct settlement negotiations with employees, or amending policies, any of that, just put it in the feedback and we can look to arranging that at a later date.
Yeah, so that's one of the very, very important bits of this session, is to get that feedback from you, because we don't really know what you want and give you what you want if we don't hear it from you. I think let's start. Welcome, everybody. My name is Nayoka Lewis, and I'm the Funding Group Development Officer at Ealing and Hounslow CVS. My colleague, I'm joined by my colleague, Ian Elliott, who will speak to you in a minute, and also Nazim Shah, who is with us, who will be leading the session today, who's the expert. He's also a trustee, so we've managed to get the best. Ian, on to you.
Thank
Ian,
you.
do you want to say a couple of words? I think he can't hear me.
Sorry?
Do you want to say a couple of words?
No, I think we let Nazim go on with it.
Over to you, Nazim.
Thank you very much. Good evening, everybody, and thank you for joining me on a Thursday evening to talk about the fascinating subject of employment contracts. And I know you're all probably very, very excited to go through this today. Unfortunately, this side of things is rather dry, and I accept, but it's potentially one of those things which can cause you lots of problems later. So it's important to understand the legal implications and requirements that are on you as an organization, as people either involved in or running an organization, and what you need to do. Now, why an employment contract, first of all? Well, in the English legal system, and I'll say the English legal system because it varies depending on jurisdiction, you can have a contract that's not in writing, and that doesn't really say very much at all. So if I said to Nyoka, it's a nice mobile, I'll pay you £30 for it, that's potentially a contract. And if she hands that over to me and I hand her over the money for the mobile without having said anything, that is potentially a contract that we've agreed amongst ourselves, and the law can add bits into it if it needs to. So a contract in law can be written, unwritten, it can be verbal, it can be implied, it can be express. Express would normally be whether verbally or in writing you agree certain terms. So those would be express terms. Implied terms would be those that would be needed to ensure that the contract could be fulfilled or executed. And it can cause all sorts of problems if you don't get that contract right in the first place, especially as an employer and an employee, because that contract is going to define what your expectations are, what your obligations are, and what you expect from your employee and what their obligations are towards you as an organization. So it's always better to have a written contract of employment, setting out everything that you expect from your employee and everything that they can expect from you. If you're going to have employees employed by the organization, you also need certain terms to be provided in writing to the employee anyway. So not having a contract of employment is one thing, but under the Employment Rights Act, you need to provide a written statement of particulars to the employee. And I won't go through them one by one because there's a few there, but things like the employer's name, the employee's job title, description, start date, how much they'll get paid, the hours, all of that has to be specified in writing. This document will be available to you hopefully at the end. So don't feel rushed trying to read through what's written there. But yeah, I mean, things like probation, holidays, and anything that's in the contract of employment is a part of the contract, unless you say something along the lines of the employee is directed to the grievance and disciplinary procedure. If that's all you say, that will also be a part of the contract. So if you don't adhere to that policy, that will also be a breach of contract. And you need to be quite careful of what you include or exclude from there, because if inadvertently you include something like the grievance procedure or the disciplinary policy and you don't follow it because an employee hasn't got the 2 years service, they can bring a breach of contract claim and end up taking you to a tribunal or a court on the basis that you breached the contract against them. So it's important to get the contract right between both parties. if you fail to give the written employment written statement of particulars, this is something that's known as a piggy bank claim in the employment tribunal. And if you fail to do this and the employee has another valid claim that they can bring, they can also bring a claim for failing to provide written statements of particulars, which can award them, I think it's 2 weeks salary. If you amend the terms of their employment and don't put it in writing to them on the above grounds, then that's a further 2 weeks. So you can end up paying them 4 weeks salary in addition to all the headache and the legal costs that you'll have to incur going to a tribunal simply for not doing something which you're required. So yes, there is an incentive for you to actually do this at an early stage and provide this written information to your employees. And if you're going to provide all of this as a written statement of particulars, it's not much more to actually provide a full written contract of employment, which I'm probably sure you most likely do as organizations in any event. But it's important that this is not something that's overlooked or forgotten about, or that you think maybe it's not that important. As long as they do the work, that's fine. That's potentially where people can start getting into problems. So if you want to avoid lots of stress and potentially costly situations in the future, when you provide your written statement of particulars, turn that into a contract of employment, because as long as it's in writing, it doesn't matter if it's in a contract of employment. As long as that information is conveyed to the employee, you're safe. So that's probably, if you haven't been doing it already, I'd suggest that you look at that and consider that. Now, we've recently heard lots about firing and rehiring, or larger employers trying to change contractual terms and change the terms on which employees are engaged with them. It is possible to change contractual terms, but that again depends on what you have in your contract. Some contracts of employment have a clause which allows the employer to amend some parts or all parts of the contract if they give sufficient notice. Say, if the clause says we'll provide the employee within 28 days of any contractual change a written copy of the change to the terms, and if the employee doesn't challenge it, or the employee has 28 days to dispute this, and if they don't, the terms are applicable. That would give the employer the right to change any of the terms. So if you have to change hours, you have to change a salary, even if you have to change the job role or the place of work, you can do that with that clause. And that can be extremely important. But if that clause is not there, then it becomes quite tricky. It's about that time that you'd probably need to go see an employment solicitor and say, well, I want to change terms and conditions. What can I do? So if you don't have a clause in your contract of employment which gives you the right to make unilateral changes, what you'd need to do is you need to send a copy of any of the changes that you want to implement in the contract to the employee, and you need to give them a reasonable period of time in which to object to that. So say if you gave them a month or 2 months, that would generally be considered reasonable. If they didn't object to the changes within that time, then it's assumed that they've accepted the variation to the terms. But say you've changed somebody's hours, or you've changed somebody's rate of pay or their place of work. If they turn around and say, well, I'm not happy with that, you've got a bit of a problem. Because the next step then would be for you to give them that notice, and if they don't accept the variation, you would have to force that change of contract. So you would have to say, well, okay, yes, you don't agree with it, but for whatever business reasons, we need to make that change. And if you have employees who've got more than 2 years service, that could lead to potential unfair dismissal claims and breach of contract claims. A breach of contract claim doesn't require 2 years service. And if the contract is ongoing, the employee would have to go to the county court to bring that claim. If the contract is finished, they can bring it in an employment tribunal along with other claims. So if you're going to force through a change, say, to the rate of pay, so instead of giving somebody £10 an hour, if you say, we're only going to give them the national minimum wage now, then that would be technically a breach of contract, unless they accepted that change. So if the employer says, I'm changing your rate of pay, the employee says, no, you're not. The employee has the right to actually consider themselves dismissed, to reject the unilateral variation and claim breach of contract, but carry on working, or alternatively simply accept the change. So what you would normally find is employees either consider themselves constructively dismissed at this point if they have more than 2 years service, or they say, yes, you've changed our terms, but we are going to continue working and we want to stand and sue. We want to take legal action. And you get into that situation where they are continue working for yourselves, but they are actually taking you to the tribunal. And unless you can show some substantial business reason for the change, you are likely to get into trouble. If, say, you've decided to change hours on a whim, or not because there's a business need, or you can't show a business need for it, the tribunal or the court is likely to say that, yes, that is a breach of contract. There isn't a good reason for that, so we're going to side with the employee on this matter, and that could be quite costly. So that's the process you'd have to take in a snapshot, is write out the variation to the term you want, pass it on to the employee. If they accept, fantastic. If not, then try and convince them. If not, impose the change and deal with the fallout. The easiest way of doing it is to have that clause in your contract which says we can amend any terms of this contract at any time in accordance with the needs of the business, or words to that effect, and that would safeguard your position. Now, I'm going through this at a fair pace, so we might finish early, guys.
There is one question. Would you like to take it now?
Yes, sure.
I have a question on the chat from Sheila, who asks, who's put this question: do we need a contract for a charity organization who engages with youth volunteers?
Youth volunteers, that's right. I can see it. Let me finish off with the employee requests, and then I'll come to the questions, I think, because those are interesting questions. They might need a bit of a detailed answer. So employers are not the only people who can request a variation to the contract. Employees can as well. And by employees, I mean the strict definition in the Employment Rights Act, who are employees, not workers. there's a section in the Employment Rights Act 1996 which allows employees to ask for flexible working, and they don't have to give a reason for it. But if they have concerns like childcare or caring for a dependent relative, then that could also lead to issues such as discrimination or unfavorable treatment. So that's something you have to be aware of, and something you have to be careful of. But an employee can say, instead of working your 9 to 5 shifts, I want to work 10 to 6 or 10 to 4. And an employer can only refuse that request on a number of statutory grounds, such as the business, it would affect the quality of the work, or the business cannot meet customer demand because of it, or other similar conditions that it relies on. Now, if that's refused, then that can be challenged. If it's allowed, the effect that it has is any variation that's agreed between the parties is binding. So if the employer agrees that an employee can come to work from 9 o'clock till 6 o'clock instead of 8 till 4 or 7 till 3, then that is the contractual term that will move forward from there. Or if that's agreed, or if it's agreed that instead of working 9 till 5, the employee will work 9 till 1, and the requirement for the salary is not prorated, then that employee will in effect be working a 9 to 1 job and still getting paid for a 9 to 5. So that's something that you have to be very, very aware of. So if you agree any variation in that manner, what you would more likely have to say is, we agree to a reduction in your hours and pro rata your annual leave, your wages, and all other benefits to you on that basis. Otherwise, you might have an unlawful deductions claim against you. So that would alter the contractual position, and that contractual position will last all the way until another variation is agreed. And it's really important, because one of the ways in which you can amend terms to a contract is by mutual consent and agreement. So if you want to change a contract, it's important to discuss it with your employees first and try and get them to agree to it, because if they agree to it, regardless of whether you have the right to change it or not, if it's agreed between parties and signed, hopefully, because I hope you would be doing things in writing and getting signatures, then that's binding. And even if the employee then wanted to object to it, they couldn't do so. That was rather brisk, but I will come back and clarify anything if anybody needs to ask for clarification on those points. Now, let me just see. I'm trying to. Sheila, I believe you asked, do you need a contract for a charity organization who engages with youth volunteers? It's not a requirement, but it would be sensible to have such a contract, simply because what if the volunteer claims that they're actually a worker or a self-employed contractor or an employee? So it's always important to have a contract for volunteers, just setting out that the fact that you're providing this opportunity to the volunteer does not mean that they will become employees or accrue any employment rights, and that their service is completely voluntary. and does not create any form of contractual relationship between the parties. So you don't need a contract for volunteers, but it's important to have such a contract. Sorry, my laptop doesn't die because of a low battery. For a second, so thank you. Okay, yes, and Lisa, you asked if this applies to self-employed contracts. Self-employed contracts are not contracts for employees. A self-employed contract would potentially be something that creates a relationship between you and the individual, which creates worker status. Now, we haven't discussed worker status, employee or self-employed, but if you think that's helpful, I will go through it briefly. But a worker is not the same as an employee. A worker doesn't have the same rights, such as let's see, the right to dependence leave, the right to maternity and paternity leave, the right to sick pay, those sort of rights, and the right to unfair dismissal. Only employees enjoy that right. So if you're a worker, you have the right to holiday pay. You have the right to bring on claims under the Equalities Act or under the work time regulations, but you wouldn't have the same rights as an employee, and you'd be free to contract with other people to do some work. Self-employed, if you're operating as a business, that would be a business contract between yourself and the organization or company or the individual who is possibly a sole trader. So it would be business to business rather than something that would come under the Employment Rights Act. Yes, self-employed can come under the IR35. It's not something that will. The IR35 is quite a new development, and it's anyone who's a worker. So if you're supervised by the people you're working for, and you're not genuinely operating as a business, either as a sole trader or as a limited company, then IR35 means that your employer pays your taxes, and you are a worker, not necessarily an employee, but a worker. So yeah, IR35 does tighten that up quite. So if you have, I'm not sure if anybody here does this, but if you had the if you'd adopted the practice of getting an umbrella company to do your payroll, and they were the people who were, like a lot of recruitment agencies and other large organizations, the NHS itself at times does, which is to engage people on short-term contracts and class them as self-employed and ask them to invoice you. And yeah, unless that was a genuine situation, IR35 would demand that the employer actually pays their national insurance contribution, well, at least the employer national insurance contributions, and process their payments through as PAYE. So it's changed the situation quite drastically in relation to how things were operating prior to this. Does that answer your question, Sheila?
Sorry, Nazim, can I maybe have like 5 minutes of your time at the end so I can explain what we do?
Sure.
Because it's more like they would be freelance staff. Because it's yeah. Thank you.
Okay, no, that's absolutely fine. If you don't want to discuss specifics, and you want to ask general questions, you're free to do so, and I will answer them now, because I don't think there's any other questions that have come in. So I have no problems as long as it's not something that relates to individuals. It shouldn't be an issue.
No. Okay, so so whereas sports clubs, usually sports clubs, they have people in on a like self-employed, like freelance basis. So the instructors, because there's never enough hours to offer them to only work for us, they work in other places as well. So it would be like for them, they would pay their own tax. You know, they don't get sort of sick pay and this is how I worked. I was freelance, so I didn't have any sick pay, holiday pay. So I was like a self-employed person. Do you still have to? So would that be called like more of a an agreement between, say, the club and the freelance, say, instructor? Is that how you would do it rather than a contract? Or you would also get them to sign that they agree to the terms of the club agreement?
Okay. If your intention is to ensure that they remain self-employed and not employees or workers within IR35, then you'd have to satisfy some of the legal tests. And if you are supervising their work and you are defining their hours and you are exercising control over the work that they are doing, then you're likely to fall foul of IR35. If, on the other hand, they are operating as a genuine business, so they are contracting with others and they are providing that service to other people. I mean, I know we're talking about sports trainers here, but say a plumber. If a plumber is genuinely self-employed and plying their skill and trade for financial gain, then they are operating as a business. And if they are the people who are going to be responsible for the quality of work that they are providing, then yes, they are more likely to be self-employed contractors in the genuine sense that they'll be operating as a business. So the fact that they are sports trainers doesn't necessarily include them or exclude them from IR35 itself. It depends on the details of the engagement, actually. So if they have a limited company, or even if they're unincorporated, but they pay their own taxes, they are advertising as a business, and they are engaging with more than one provider or customer, and they genuinely negotiate terms, then it's more likely that they would be a business and be responsible for their own taxes in relation to the IR35 and the employment status. Ultimately, though, it's a decision. If they wanted to challenge it, it's a decision for an employment tribunal.
Okay. So if they worked in other places also as a self-employed person, but they've not set themselves up as a business,
yeah,
they could be so they could be working for other organizations as a self-employed person, and then they have rights of sick pay, holiday pay. Is that what you're saying?
No, well, they'd have rights of holiday pay, not necessarily sick pay. But you know, it's like the Uber drivers case recently. That's a good one to use. I mean, it went all the way to the Court of Appeal of the Court of Appeal, and it was decided that because Uber exercises control over what jobs they can and can't refuse, and they were being monitored on the level of service, and technically they could come on at any time and leave at any time, but they were paid for that period. They were workers. and they were entitled to holiday pay. So that's what you've got to be careful of. It's asking for a definitive answer on that would require considering all the facts, and that could be quite a thorough process. So it's not something that really could be done in 10 or 15 minutes. That would be something that requires formal advice.
Okay.
Yeah, but as long as you can show that they are free to engage with other customers, whether they're incorporated or not is not the test. So there can be what we have know as a sole trader, as an individual who's not incorporated, or as a limited company. Either way, that's just the way in which they conduct business. But the point is they must be conducting business. So they'd be engaging as a business with another business. And that's when the IR35 would say that they are actually not an employee or a worker.
So, you said about the hours thing. So basically, it's like with mutual agreement. So we'd probably say we need this amount of hours filled, for instance. What ones can you do? And then they can choose to pick up or drop at any time. So
Okay.
Would that still be under the worker or business self-employer, or?
Any one consideration is not sufficient to determine their status. So if they couldn't turn up for the hours, but they could send a substitute, would that be acceptable?
Well, we would make arrangements for it, because for instance, sport is very specific. They have to be to be able to be for us to be insured. They couldn't just like bung anyone in. They would have to be an appropriate person with a certain level of qualification. So it was like we would fill the gap rather than them putting someone in.
That would complicate matters. If they could provide somebody of suitable qualifications and competency to do that role, and you had the power to refuse, it would be likely that they were workers rather than self-employed. Because think of it this way: if I'm going to say I need a taxi, I'll use this example because it's quite stark and it's relatable. But say I want to use a taxi, I call the taxi rank, I ask for a car. I can't determine who comes to pick me up and drive me. I can complain about the service afterwards, saying, "Don't ever send that person again. They're no good," or "I don't think that person's got a driving license." But you would assume that as long as they have the necessary qualifications, competence, and they've met all the legal criteria, so they have a taxi badge and they have the insurance, you wouldn't have any say in who provided that service to you. Now, if somebody's operating as a whatever their role is, as a sports instructor, trainer, and you said, "I need this service from this time to this time," and they couldn't make it, but they sent somebody else who was equally qualified, if you can refuse that person, then you're not likely to be in a relationship where they are contractors. It's more likely to be a self-employed worker.
Okay.
Does that help?
Yeah, so I need to look up what the obligations are in both sides of a self-employed worker. Yes?
You'd probably need legal assistance on that, because it's quite a tricky and difficult area. It's not clear cut, because even when you have all the facts, it's a judgment that if things go wrong and that person makes a claim in the employment tribunal, then it's up to the tribunal to determine that. Or with the IR35 regime, it's HMRC who determines that. So you might have a belief that somebody is a self-employed contractor, but legally the reality might be quite different. So I would suggest you seek legal advice if you're at that stage, and that's the query that you have. So yes. Do you need clarification on any other aspect of that, Lisa?
No, I think that's fine. Thank you.
Excellent, thank you. Yes, I think, yeah, Sheila.
Sheila, if you want to get yourself off mute, you can do that at this point.
Yeah. Hi.
Hi there. Yes. You asked the question about umbrella companies who charge you a maintenance cost. Now, if there's a contract between an umbrella company and an individual, and it turns out that the employer is exercising control and there's no right to substitution and they are classed as workers, then that umbrella company will be liable for all the tax and national insurance and the employer's national insurance contributions. So umbrella companies at the moment are, if they've had any legal advice, they're frantically trying to get their houses in order. And you know, you'll probably see an increase now where people who were normally paid through umbrella companies are now having different contracts being put forward so that this is all covered. But even if there are contractual terms, so an umbrella company could say to the individual, oh, nobody's going to supervise your work, you're responsible for the quality, and if there's any defects, you have to remedy that in your own time, you won't be paid for that. And you know, you can send anybody in. If it goes to a tribunal, they don't look at what's written on the paper, they will look at the actual circumstances and you know, what the actual arrangements are between the parties. So if it says on there that you can bring somebody in for substitution if you can't attend, but in reality, the company doesn't allow substitution, or says, okay, if you need to substitute, you have these people, you have to choose, ask one of these, or ask one of the colleagues already working here if they can cover. That would more likely than not go against what they were arguing, and they would end up being liable for the employer's part of the NI contributions, and those people would fall within IR 35.
Okay, thank you.
Do we have any further questions? Hopefully nothing too difficult.
Yeah, I think there can be an issue with like volunteers in terms of like offering them vouchers, isn't there?
Yes. Yes.
Interpreted as a contract, or if you offer them
not
anything.
Necessarily a contract, but if you pay anything other than expenses to a volunteer, that becomes taxable. And then, although it might be accepted that yes, they are still volunteers, that could be brought into doubt, but there would be the added problem of HMRC wanting a portion of that. So the only thing you can really pay volunteers are expenses such as travel costs or you know, lunch costs or something, but nothing more than that. So if they incurred some photocopying fees or they bought something for the organization, they can recover that, but that has to be clearly documented. I believe everyone's really quiet, so I'm not sure if there is anything else that I can answer for anyone. Any further questions? Any takers? No. Okay, so it's I'm not sure if it's 20 past 6 or 6:15, but it's around that time. So Nayoka, do you?
Yeah, I'll be putting in the link to the feedback in the chat right now. In fact, I just clicked it there. Like I mentioned before, if you do not give us feedback, we don't know whether you need support or what kind of support we can provide you here. So do click in that feedback form. It won't take you more than 2 minutes, and it will give us a lot more important information. So look forward to that feedback. And thank you for joining us today. We meet again next Thursday, the same time, with Nazim on another session. This time we would be talking about HR.
Policies and
HR
why you
policies.
need them. I'll try and keep it brief and to the point like this week. So hopefully you won't have to listen to me for a full hour, but I will try and get everything that I need in there.
Yeah, and we'd also like for you to bring in any kind of questions or issues that you, or like a case study or something that you need to discuss. And Nazim would be happy to, discuss that at the end. So we know what areas of the particular topic. The topic is huge, and it's just not possible to finish all of it in an hour. So we're trying to pick on the overview right now. Once we know the details of which part of the session you need more support on, we can try and tailor another training session on that.
Okay, well, I think if you could all complete the feedback before you go, I will leave you to talk amongst yourselves and leave you to enjoy quite a pleasant evening now, actually. So thank you for bearing with me and listening to me, and hopefully I'll see you at the next session.
Thank you, Nazim, for your time today.
Thank you.
Everybody.